Okay, everybody, I'm going live right on time. I cannot believe it. It is 8:30. It just turned into 8:31. We're going live to discuss quite a bunch of issues. Going to give everybody a moment to get logged in that wants to log it in. I know this one was not announced as much in advance as I normally do, but I thought there's a lot going on, so I thought it'd be important to go through everything that's going on, talk about the issues, and talk about what we're doing now, where we're going, and where do I see things going, and what we can do about some of the many issues that we've got. First thing I wanted to address is I've heard some crazy things about our march on OMMA. I've heard things like we vandalized cars. The only vandalism to a car was by an employee of the Department of Health that in the dirt on his car wrote "fuck you." So when he drove by everybody on both sides, they could see that he'd written that in the dirt on his car. So that was self-vandalism. Obviously, we've heard about the threats to Adrian Rollins. Obviously, we don't condone that. That's ridiculous. We kind of have an idea who's behind that. They've blown that way out of proportion. It just goes to show one bad actor can try to screw stuff up for everybody. Hey, Steve, Tyler, Chris, or Grumpy. I always switch between the two. Everybody else, Walter, Christy, Anthony. So, we don't condone the threats. They're using that as a ploy to try to deflect attention off of what they failed to do. It's sad that the media has let them get that. And honest to God, it's sad that the people in this industry and the supporters of the movement are letting these false rumors, and they're spreading these false rumors about what happened there. Everybody was extremely peaceful. Yeah, there's a few people that shouted every now and again. But honestly, the Department of Health woman who was the gatekeeper downstairs started yelling at everybody. And that's where, if any yelling occurred, she started it, trying to tell everybody that we were on camera and being filmed while 30 people were holding up cameras, Facebook Living the whole thing, like we were concerned about being on camera for some reason. So anyway, the death threat's ridiculous. That's what happened. Posting her home address, asking for people to go there. I mean, let's be smart about these things. Let's not do stuff like that's going to make us look bad. That's all I'm going to say about that. I thought it was a fantastic rally. The people that were there were amazing. Everybody was awesome, other than the Department of Health workers. And so let's put that to rest. Let's have another good rally here coming up soon. We're going to get that going. So things you want to know about. First thing is an attorney stopped by today. Unfortunately, my office didn't bother to let me know he was here. But he's filed a lawsuit on behalf of Sooner Green versus the OMMA and the city of Sulphur. He emailed the pleadings over to me after he stopped by, or maybe they scanned them while I was here. Anyway, I've had a chance to read those. They make some good arguments with regards to some things. I think they need to go a little further. I'm going to talk to him tomorrow, give him a shout. They named the OMMA as opposed to the Department of Health, which is the true entity. So I think there's some things that need to be corrected there, some things that we can add to that. But I'm certainly going to jump in and lend support in every way humanly possible to that lawsuit. Just so you know, that lawsuit was filed in the Oklahoma Supreme Court, and there was an application to assume original jurisdiction, which means that if the Supreme Court accepts it, they can decide this case and be the final and only arbiters of that, so we don't have to work our way through a court system. So that was I'm fully supporting that. I think the arguments are great. Again, I think there's some other arguments we can add to it. I want to get some of those added to it so we can move forward. If nothing else, we're going to do what's called an amicus brief. So we will essentially, while we're not part of the case, we will essentially ask the court for permission to submit briefs in support of their position against the city of Sulphur and against OMMA. The lawsuit is about the certificates of compliance. And where I don't think it goes far enough is I think, honestly, like one of the things that can be challenged is just challenging 1030 and challenging that part of 2612. I think there's some additional avenues maybe for some results there. So want to help them and support them. I was a new lawyer. I'd never seen involved in any of this stuff. So that was great to see that there's another lawyer out there, and I guess Sooner Green got sick of stuff and stepped up and is paying somebody to file that lawsuit for him. So kudos to Sooner Green. I guess they're trying to be in the city of Sulphur. So don't know them, but kudos to them. So moving forward, where are we going to go from here? What lawsuits are we looking at filing? And by the way, if you guys are facing a particular problem, this is the perfect video to put your comments in. If you don't know this, I go through and read every comment. I try to respond to everybody. I don't get to everybody on a response, but I try really hard to respond to everybody. So if you've got a comment about some area that you think is a huge problem and we need to be looking at as far as challenging it, don't give me credit for not overlooking something. I will overlook something or not realize it's an issue if people have not told me that it's one of the things that they're facing. So post anything in the comment thread here about any issues that you guys are having as we move forward through this this whole process of lawsuits. So here's the things that we're going to challenge. First thing I'm going to challenge, we're filing a lawsuit. It's a separate lawsuit, but it's going to completely challenge Senate Bill 1030 related to the zoning ordinances and requirements. We've got some arguments. I've got the research on it done or almost done. I think we've got some fantastic arguments to try to take the power back from the cities and counties that have been essentially given carte blanche authority to ban, as a matter of law, growers and processors, and if not as a matter of law, as a matter of practice, they can essentially ban dispensaries from operating in their cities or counties. So this to me is the huge one that the Oklahoma Municipal League and the county has got them to put into this bill. Fortunately, I think they did it the incorrect way and put it in a bill they shouldn't have put it into. And because of that, I think we've got some arguments to challenge it and beat it. And hopefully any lawyer considering that watches this that considers filing such a lawsuit will contact me so we're not filing multiple lawsuits and we can team up to file these things, because I ain't after the glory. I'm just after beating the damn law. So I'll work with anybody on challenging any of these things, provided that you're halfway competent. So what are we going to challenge? So, when we're looking at some of the things we're going to challenge in 2612, and this is not an exhaustive list, one of the first things we have to challenge is and let me caveat this. I think all of the medicine in the state of Oklahoma should be tested. I think it should be tested for contaminants. It should be tested for pesticides. It should be tested for, heavy metals. It should be tested for poisons. I think it should be fully tested. So I am on board with testing. Just want everybody to understand that. The problem with the way they pass these regulations is it says that all this product has to be tested, and there are no OMMA-approved laboratories to test anything. And so if you follow the letter of the law, essentially every dispensary should be shut down until they approve labs and the stuff can be tested by an OMMA-approved lab. That is what I'm going to be challenging. I have to challenge that, because if you are following the letter of the law, and as a lawyer I have to advise clients, this is what the law says. Whether you choose to take a risk is the client's call. But the way the law is written, and I'm going to go through that when I talk about packaging and labeling here in a minute. I know I said I was done talking about it, but there's a lot more I think everybody needs to be aware of. And so I'm going to give some free advice to everybody that watches this. But we got to challenge the testing issue, because there are no OMMA approved labs. You cannot comply with the law under any circumstance. Can you comply with the law? And I know somebody's going to post, well, there are labs, and I get that. There are labs that have been licensed through OBNDD or through other mechanisms, but that is not what the law says needs to happen. And so, yes, my argument is, hey, if you can't get a test from an OMMA approved lab, at least get a test from one of those labs. But again, that is not a solution to this problem, because it is not a guarantee that you're not going to get shut down, or you're not going to get fined, or you're not going to get your license revoked by OMMA. And I'm sorry, I don't trust that state agency. I don't trust really any state agency, but I specifically don't trust that state agency that won't even bother to, return a phone call or give a meeting to anybody that's working day in and day out in this industry. And I'm not just talking about myself. I'm talking about all the hundreds of other people that requested meetings that day. They've not called anybody back to my knowledge. And I know somebody got a response from Adrian Rollins today. I've looked at it. If you can't tell that's a canned generic response that was copied and pasted, and the one I've seen, that's what the case was. At least that's what it looked like to me, is that there was a canned response. So we've got to challenge these things. One of the next things that we've got to challenge and we've got to deal with is remediation of product. They have no provision for remediation of product. Right now, if a grower, and it's going to sound bad, and I please don't shoot the messenger. I'll try to explain it to you, and somebody else can explain it a lot better than I can. But in Oklahoma, we have outdoor grows, we have greenhouse grows, and we have indoor grows. And in Oklahoma, because of our climate, our humidity, all of those things, We have mold that can develop on plants. The same is true with regards to cannabis. And we obviously don't want patients getting medication that has got mold on it. But there is a process that every other state that I'm aware of allows, and that is called remediation. You can take that cannabis that has mold, you can process it in a certain way, and you can remove the contaminants and remove the mold and turn it into extract that is perfectly clean, has no mold, has no other issues. But as it stands right now, that can't happen. So technically, if a grower gets a test that shows that, they're supposed to destroy the product. Well, you want to talk about putting this industry out of business? That'll work real quick. That'll put so many growers out of business, there won't be anybody left. Processors that are doing things, they might end up having something on there when they do the original oil run, if they do the test after that. Well, then there's another process they can go through, and they can create distillate, which further cleans and purifies, which is what's in your vape carts, and a lot of edibles too. And they can clean the product that way. So then it can be tested. All that stuff's removed. The test is clean. They can move forward. But in the law and in the regulations, they're not allowing for them to do that. It is, again, allowed in every state that I've looked at. That is allowed. An example I can give you is somebody that is using BHO or butane to extract. The way it bubbles out, there are some occasions where it all doesn't bubble out. That's why you test it, right? And so if a test comes back with too much butane, you can repurge the material to get the rest of that out and make it clean. But again, the way the law is written, that's not allowed. And why do we think that's the case? Because if you have to destroy it, whether it's the flour that you can't remediate, the extracts that you can't remediate, you can't turn it into distillates, that drives the price up. It makes it more and more expensive, and it puts people out of business if they're having to destroy product. And that is what I think these regulations are designed to do, is put as many people out of business as they possibly can. I don't think they understand that ultimately the free market will do that for the ones that aren't doing things as good as the other ones. Let the free market control. That's what I always say. And so that's not what they're trying to do. They're trying to do everything they can to shut it down through alternative means by making these things so onerous and ridiculous that there's no hope of possibly being able to comply. And so, that's the testing issue, the remediation issue. One of the other big issues is the certificate of compliance. I know everybody's struggling and having fights all over God and creation with that. I get calls. I don't know how many calls I get a day. It's a lot. I pretty much every meeting somebody's talking about that, it seems. And so, we got a couple of challenges here. One, I think it's what's called an unfunded mandate. I think we can challenge it on that ground. I think we can challenge on the ground that these people have already been licensed, and so you're now adding an additional requirement that's going to remove a license that they have a vested property interest in, and you've done it without giving any guidance or working with any county or city to ensure that there's a smooth transition. And in looking back at this, and I was talking to Grumpy earlier tonight, in 2612, House Bill 2612, they have a provision that says that a new applicant can apply for a license. The license will be issued provided you're in compliance with everything that's supposed to be submitted, and the license will be provisional if you don't upload a certificate of compliance. And the reason why is because a new business needs time to get into a building, get everything up to code, get everything up to snuff, get it all inspected, get the occupancy permits, and then get the certificate of compliance. So they gave these businesses a year from being issued a provisional license. They have a year to get in compliance, get the certificate of compliance, and submit it to the state to get their fully active license. And yes, there is a provision that says they can't possess marijuana or marijuana products during that time period, but they've given them a year, but they've done nothing for the businesses that were in existence before this law came into effect. There's nothing that gives any of these businesses additional time to continue to operate the way they've operated for a year and work on getting these certificates of compliance. To me, that is criminal. I think we've got grounds to challenge those things. I think we can get some injunctions on those, and we're going to challenge that and stop this insanity that we've got going on with regards to that. We've got counties all over the place that are enacting additional ordinances. We still got problems with like Wagner County, even though I've sent them over some proposed ordinances. So hopefully they'll revise their ordinances and go to a special use permit as opposed to saying that you can't grow in anything but industrial. But we'll see what their response is. They've had it for a couple of days and I've not gotten a response. So I don't know if they've changed their mind on their openness to try to work with all of the growers in Wagner County that they're now trying to shut out, including ones that were licensed before they passed this ordinance, which is, yeah, you can't do that. I think we're going to have to explain that to them in court if we have to. But That is a huge problem. So we're going to be challenging that. There's so many parts of all these things that we're going to challenge. We're already challenging an update for patients, 2 updates for patients. So Lawrence Pasternak and Grumpy and Norma have talked to me several times about a patient sort of information booklet, I guess, that has information related to patients' rights and responsibilities, what to do in certain situations, those kind of things. I'm going to finalize that. I'm working on it. I'm trying to figure out how to get it in a 3-fold pamphlet that everybody can have, so it's not like, a dissertation. I am not known for brevity, as you all know, because I run my mouth so much. But we're working on getting that information for patients to be out there. If you want one of those things, just stay tuned. When I have them, I'll announce it. If you're a dispensary that wants to carry those for your patients, let me or Grumpy or Norma or Lawrence know, and I'm sure we'll figure out a way to get those to you so you can get that information to patients, because it's important for patients to understand their rights, especially as the smoking locations law changed. They amended the laws to change where the cannabis can be smoked or vaped. So we've got to deal with those issues, and I want to deal with how to interact and handle an encounter with the police department, because we want to stop opening doors for police when they come to our house and ask to inspect our plants and things of that nature. So we're going to get that brochure out with some vital information on it, and again, it'll be free. Maybe somebody one day will cover the printing costs, but we'll get them out there. Although I'm not printing 180,000, or actually we're above 190,000 patients now. I'm not printing that many. So I'll share the PDF after that, and you guys can print them and have them in your dispensary, because, you guys can print them. That's a lot of printing. I wasn't even thinking about that. Anyway, I'm trying to look at your comments as I'm going through this stuff to see if there's anything I want to address. Somebody asked about sprinklers being required for CO2. It depends on how they interpret the fire code, and it also depends on what kind of building you're in, when the building was built, the size of the building, the material which the building was constructed in. My suggestion with any fire code related issue is call the fire marshal for your county, and if you don't have one in your county, call the state fire marshal and ask questions. By the way, you don't have to tell them that you're not in Tulsa, but if you call the Tulsa fire marshals, they're really nice guys, and they are happy to answer questions for people. So even if you're in somewhere else, it's the same fire codes for the most part. So feel free to call Tulsa ones. They're pretty good guys. And I've not heard of anybody having issues with getting things taken care of with those guys. Somebody asked, what testing labs are we allowed to use? Well, technically it says OMMA approved laboratories. That's the problem, is they don't have any. So that's where we're in with the problem. Cherokee County won't sign a compliance letter, Joe Rocky says. Yeah, I got somebody today that wants to get a license, and they got a not applicable on the first page, and they got a letter to go for the second page and said, we're not signing your damn form, Department of Health. And so we're going to submit their application and see how that goes, and that'll be a fight when that happens. So anyway, just still going through your comments. You guys talk a lot when I'm talking, which is awesome, but I can't keep up. Let's see. And don't go away, by the way. I'm going to talk about, if you're a dispensary owner or grower or a processor, there's some stuff that I'm about to talk about. It's going to take a little while. It's going to take quite a while. But it's important and vital information that I need you guys to have. And honestly, it's information I would not normally give away for free. But in this particular instance, I'm going to walk you through it. If nothing more, to encourage you to hire an attorney, hopefully a competent one like, I don't know, me. But we'll talk about that in a minute, so don't go anywhere. I'm just trying to get through some of these questions if I can. Some people are asking questions about mold. I'll have to get back to you on those. Somebody says we need legal help fighting a marijuana case. Message me, and I will respond. By the way, I'm about a day behind responding to Facebook messages, which is pretty impressive. I'm only a day behind. But if you've messaged me in the last 24 hours, I've not responded because I've not had a chance to look at them. Okay, screw. It's hard to read these questions. I'll come back and answer your questions, I promise, and get to that. So let's talk about what else do I want to say about patients? Anything else? Oh shit! One more thing about patients. Sorry. So we filed that lawsuit to block, Richard Buston and I filed that lawsuit to block the release of patient information from the Department of Health to the Department of Public Safety. The Department of Health, who has the information, and I spoke to their attorney today, and he reassures me in all uncertain terms that they have not released that information to DPS. They are not going to release that information to DPS while that stay is in place in the court case. And the reason why he called me is the Department of Public Safety, who I named as a defendant in the lawsuit, filed a motion to dismiss. They should go back to law school and realize the motion they filed was really a motion for summary judgment because they went outside the pleadings, but we'll educate them on how to be a lawyer later. But they're essentially asking the court to dismiss our case, which would then allow them to get the information that they're wanting from the Department of Health. So I was talking to the attorney for the Department of Health today, and it's already occurred to me, and I was planning on doing that. I bought some time to file a response to their motion to dismiss. So here's what I'm going to do. OMMA and Department of Health is fine not releasing patient information. They don't want to release it. They know the legislature didn't intend for that to be that way. They're going to wait for them to fix it. So what we're going to do is we're going to dismiss the Department of Public Safety out of the case. And we don't need them. They don't have the information. They can't get the information from the Department of Health because they're under a court order not to release it while the case is pending. And so I don't need them as a party. So we're going to teach them a little civil procedure 101, and we're going to moot their motion to dismiss by dismissing them without prejudice out of the case. Then they don't get a voice. They can shut up and go back to the Department of Public Safety. And we won't even have to bother to respond to their ridiculous motion to dismiss. So that's what we're going to do with regards to that, because like I said before, over my dead body is the Department of Public Safety going to get that information. By the way, over my dead body is a colloquial expression that doesn't literally mean I'm going to do anything which would result in my untimely death, just so we're clear on that. Yeah, so patient information, we're still fighting to protect that. We're going to dismiss out the Department of Public Safety and basically, flip them off and say, your motion is now moot because you're no longer a party to this case. So the court doesn't need to consider your motion, and we're not going to get any pushback from the Department of Health attorneys on that, because they were calling me to suggest the same thing, and I was like, that's fantastic. I already was thinking about that. Wanted to see what your guys' thoughts were on it. So it was a very fortunate timing of that call. It worked out quite well. So that's what we're going to do with regards to the patient lawsuit that's pending. That's pending in Tulsa County, by the way, if you don't know. It's Tulsa Higher Care Clinic who's funding the lawsuit versus, and when I say funding the lawsuit, they pay the filing fees. I'm not billing for my time, but they pay for the filing fees. So they, and I guess they'll pay for postage if we need it. But anyway, there's no attorney time being billed to them or any of the plaintiffs in that case, because that's not how I do those cases. I make money off of clients that come to me and ask me to help them with their business stuff. That's how, by the way, if you want to know how I fund this, is with the clients that I have. They pay me to do legal services, and then I use my time and money to do the shit I want to do, which is fight all this stuff. And by the way, don't get me wrong, it's a great PR thing for getting new clients. So I'm not complaining or whining or crying, I promise you. Okay. That's what's going on with patients. We got that information still protected. That's how we're going to deal and buy some more time to get to February, March, April of next year to make sure that patient information is protected. I am going to send out some discovery in that case and do some things to verify that information wasn't released. Speaking of information, the OMMA and Department of Health, we requested information when we were there at the March on OMMA last week. They have ignored that. They've not given us any of the responses to any of that stuff, even though we wrote it out and they took it up to city legal. Obviously it's my position, and I think I'm very correct, and goes to the post I did a couple of days ago. I think the law is clearly on our side that they should have given us that information that day because it was information that was readily available to them. It wasn't going to disrupt their services in any manner by making a copy of a email list. And I know it's available on the public website now as well, but that's not what I asked for. I asked for where their offices were located. I asked for their email addresses so I could go ask for appointments. And we asked for a bunch of other stuff too. So anyway, somebody says, why did Bud Scott say we should pay him to join his group to get the information? I don't know why Bud Scott says anything. So we're going to leave. I don't talk about Bud Scott for a very good reason. Let's not go on that. Although I did hear that I'm on a panel with Bud Scott. This is an interesting thing. Green Grow Expo next Saturday and Sunday in Tulsa. I'm speaking on a panel, and I'm doing another thing, speaking over there at that. By the way, I don't get paid for those things either. I just do it for fun. But I think I'm on a panel with Bud Scott. So if you're not already planning on being at the Green Grow Expo, and then the expo at the Kendall Whittier, I'll post a link to those things later. If you're not going to be at those things, I'm speaking for 4 days in a row. I'm speaking at things in Tulsa. So if you want to come see what that's about, I know the first event, which name is escaping me, and I should know what it is. That event is free. Green Grow Expo costs some money, but they put on a fantastic event. So if you've not been to one of their things, I highly recommend. It's worth the money to me. And again, you're going to get to hear me on a panel with Bud Scott, which could be very interesting. Depends on if there's somebody there to hit me upside the head if I get out of line or not, but I won't bring that person. So should be a fun occurrence, unless he cancels. Not sure if he wants to sit on the same panel with me and go toe to toe on some issues, but we'll find out. It'd be fun. Maybe it'll be a very meaningful conversation. I hope to God it could be. I would much prefer that, but I have my doubts. Anyway, on to the important stuff, and I cannot believe at 8:57 there's 218 people watching this live. But getting into one of the reasons why we've got to challenge some of these things is, and why we've got to challenge some of the things related to testing and packaging and labeling and related to certificates of compliance and all these other things. There's some important things that you guys as growers, processors, and dispensaries need to know, because there is mass confusion out there related to what are the obligations of each of these entities. And folks, I'm telling you, these are my notes from going through the regulations and just pulling out stuff related to packaging and labeling. These are my notes for myself to make sure I know what all the requirements are. So when I'm reviewing a package for a client or a label for a client, I can make sure that I'm in compliance. I have to go through all this stuff just to make sure one package is in compliance with all the damn new packaging and labeling requirements. So let's go through these things. If you're a patient, I'm just trying to keep medicine in your hands, and you have to have access to it. This information won't be that relevant to you directly, but I think all of this is important to all of us, as it really is going to dictate whether this industry lives or dies. And again, I'm not trying to be Chicken Little, the sky is falling, but they might not enforce some of these things. I understand they might not enforce some of these things, but we have no guarantee in the regulations or any official statement from OMMA or the Department of Health that they're not going to do these things. They're not requiring these things. And so it has left everybody exposed beyond recognition to liability and being shut down and having licenses revoked for failure to comply with these new regulations. These things terrify me to death, because we have no promises that they're not going to start hammering dispensaries on this. And it's unlikely. I don't think they're going to. But again, we have no assurances of that. So let's go through what all the law says and why we have a myriad of problems related to these things. And you'll notice at the office it's Diet Coke, because I don't keep alcohol at the office. Anyway, let's go through it. It says, one of the first things I need to point out, and this is very important, pay attention to this. It says commercial licenses. That means growers, processors, and dispensaries. So this applies to all of you. This is where a big point of confusion comes. It says commercial licensees shall not sell, distribute, or otherwise transfer medical marijuana and medical marijuana products that are not packaged and labeled in accordance with the Oklahoma Medical Marijuana and Patient Protection Act and these regulations, or these rules. So again, this applies to growers, processors, and dispensaries. All of you, if you're selling a product, it has to be properly labeled and packaged, period. And I know a lot of people think growers can continue to throw in those bags that they're talking about. That is not what the law says at all. It says they are required to be in compliance with that. And do I think you can still sell in bulk? Yes, but you're going to need to label the bags properly, make sure they're proper bags as far as all the other ridiculous requirements for packaging. They should have been excluded, and it should have been talking about only things need to be packaged in these ways and labeled in these ways upon transfer to the patient. There's a part where they try to mention that, but they do it in such a way that it doesn't fix anything. So that is what the Act says. And you can go, and it references Department of Health Regulations 310:681-1-1 et sec, which means all of these damn rules and regulations. So that's an important thing to understand, and that's why we need some clarification related to these things, because these things should not apply to growers selling bulk flower to a dispensary to be deli styled out to patients and labeled in accordance with what they've purchased. It makes no damn sense that a grower should be required to make sure that their stuff is packaged properly. So then what do we go to next? And this is where we run into a lot of problems. And this is specifically to dispensaries. The regulations say a dispensary shall refuse to accept or shall return to the licensee transferring medical marijuana or medical marijuana products to the dispensary any medical marijuana or medical marijuana products that are not packaged and labeled in accordance with the Act and these rules. There you go. If you are a dispensary, you are on the hook to reject any product that is not properly packaged and labeled in accordance to these rules. And one of the problems that we have in the system right now is dispensaries are buying from 30 or 40 different companies. It's a mess of packaging, and you get so much to check in. I've got a solution for that. I'm working with a group to essentially, they'll verify all packaging. They want to act as distributors, but they've come to me and said, hey, what if we paid you to inspect all the packages of all the products that we're going to carry and we're going to distribute to dispensaries so they can do one order from us, know that the packaging is in compliance, and we can ship it to their dispensary. I was like, that's a damn good idea. I can get behind that. Give me some more details. We're working on that. That's a fantastic, awesome idea. And they said that they're going to pay for the review. So I thought that was pretty cool too, to get because one of the things I was talking to a dispensary owner about in Tahlequah the other day is like, how are you going to do this checking in 40 different products, 50 different products? And they were wondering the same thing. If I'm not standing there with them, how are they going to be assured that they don't miss something? And that's a legitimate concern that I have, because it could result in fines. It could result in multiple violations, could result in them trying to revoke licenses. So anyway, a dispensary shall refuse to accept, and notice the other part, or shall return. So the problem I've got is, what about all the product that you've got that's non-conforming in your shop right now? Well, the way this reads is you shall return it. Again, this is why we need clarification from OMMA on what in the world we're supposed to be doing on this. This is why we're asking for meetings. We're not trying to be difficult. We just need some guidance and clarification on what they want us to do. I don't think that's asking too much. What would you like us to do? Please tell us so we can be in compliance with what you want. But if you don't tell us how you want us to handle these situations, we can't throw tens of thousands of dollars worth of product in the trash can. It doesn't work that way. The thing goes on to point out this. It says, and this is for growers and processors. It says the commercial licensee who sold or otherwise transferred the non-conforming medical marijuana or medical marijuana products shall accept such return. So this says if you're a grower or a processor and you have non-conforming goods out there and a dispensary contacts you, it says you shall accept such return. That's what it says. That's the regulations. And then I love this part, because this is the big screw you to dispensaries again. It says if circumstances are such that a dispensary cannot return or refuse to accept the non-conforming medical marijuana or medical marijuana products, the dispensary shall dispose of the non-conforming medical marijuana and medical marijuana products in accordance with the Act and these rules. And you have to document that you either returned it or you destroyed it. So what it says is, very clearly, growers, processors, and dispensaries have to sell their product in containers that are properly labeled and packaged. Okay? A dispensary owner cannot accept those things. Really, nobody can accept those things if they're not properly labeled and packaged. So that means the processor as well. If some of that comes to you and you're a dispensary owner, you are required to return it or reject the product. If you try to return it, they are supposed to take it back. It says they shall accept such return. But then it says if they don't accept such return, you shall destroy the non-conforming product. So what do we do here? That's, again, going back to why we're trying to ask for these meetings to figure out what we need to do. And the documentation of what you need to do to show that you've done your due diligence is pretty ridiculous on all the stuff that you're supposed to note related to these non-conforming products. Again, we're just asking. I know OMMA watches these damn things. They have somebody that watches this feed. I know they do. Or maybe that's just my ego. I don't know. But if you're watching this, this is what we're trying to get clarification on. This is why we're asking for a meeting. We don't want to be confrontational. We just need some guidance related to all these issues that I talk about on a regular basis. So anyway, that's what's required of you. And we don't know whether they're going to show up tomorrow, if they're going to give us 30 days, they're going to give us 90 days. We have no idea what they're going to do with regards to enforcing this provision, because it is in effect. These things were in effect on the 13th and the 14th. So this is the law. This is what you're supposed to be doing. So anybody that's not doing this is technically breaking the law and breaking the regulations. So that's why we need guidance. That's why I'm so on everybody about getting your packaging updated, getting packaging solutions, getting labeling solutions. That's why I keep talking about the damn packaging and labeling, because this is the one clear thing that I think they could go into a dispensary and then track it all the way back to the grower and processor and start tagging people for. So if you want to know why I keep harping on this issue, that is why. So let's keep going through this stuff. There's still 212 of you. I haven't bored you to death. So let's talk about the general requirements. And again, I want you all to understand, I would normally never do this for free, give you this much detailed information, because it takes me a lot of time. And this is how, as a lawyer, I make money, is by giving advice and advising clients on how to be in compliance with things. So please understand that I'm doing this in this regard, and I'm giving you the best information I can give you. This is not the full information. Yes, this is the full information, but there's more to it than this. There's ways to do things. There's procedures that you need to have in place. There's checklists that you need to have in place. There's a reason to hire a lawyer. And so, feel free to watch this video 15 times and try to put that stuff together yourself. If you need to circumvent, hiring an attorney for that reason because you don't have the money, then, more power to you. I'm obviously doing it on my own free will. So let's talk about the general requirements for a package. General requirements are: product must contain a batch number from the grower/processor. So every product in the packaging must have a batch number from the grower/processor. And it could be two. It could be the batch number from the grower that went to the processor that came to you. So the way it reads, it's not clear on that. So you need a batch number on all products. Then also, the product must be child resistant. I've talked about this ad nauseum. There's a 2-hour and 15-minute plus video about packaging and child resistant, but we're gonna go through these quick. Child resistant means packaging is significantly difficult for children under 5 to open and not difficult for normal adults to use properly. And you need to go read 16 CFR 1700.15. So if you Google 16 space C period F period R period 1700.5, I think Cornell Law School has a thing where that information is provided there. You can read what that CFR has to talk about. It's free. So go check it out and read what it says. But you need to have packaging that is difficult for children to open and not difficult for an adult to open. And then it says packaging is opaque, so that the outermost packaging does not allow the product to be seen without opening the packaging material. Not getting back into the argument about whether exit bags, I think we've killed that. Exit bags don't work, period, because it can't comply with the packaging and labeling requirements. Because also it says that a package must contain a label. So the package must contain the label. All right. This is a big one that's going to get a lot of you folks out there that are designing these pretty new packages. I've seen some damn pretty packaging. Unfortunately, it's not freaking compliant, is the problem. And you guys are missing things, and the packaging designers are missing things, and it's a problem. So here's what you're missing. The normal thing, fine, it must not be attractive to minors and shall not contain any content that reasonably appears to target children, including toys, cartoon characters, and similar imaging. But then it says, packaging should be designed to minimize appeal to children and shall not depict images other than the business name logo of the medical marijuana producer and an image of the product. So what they say is the only images that your product packaging can contain is your business logo and an image of the product. That's it. That is what they're saying is required. Now, how do you determine whether your logo is, it talks about you can't have cartoon characters, toys, similar images. I don't know how they're going to find similar images. That's pretty damn broad. Yeah, he gets around that by saying, hey, guess what? It can be your logo and a picture of the product. That's it. I mean, it very clearly says that in the regulations. Going down the list, and if you're keeping track, we're on number, I don't know, 4 or 5. The packaging must contain the statement, keep out of reach of children. Pretty easy. It needs to say exactly that. Keep out of reach of children, period. And then it says all medical marijuana and medical marijuana products must be packaged in child-resistant containers at the point of sale or other transfer to a patient's parent or legal caregiver if the patient is a minor or caregiver. Well, we've already talked about the fact that that's where the confusion comes in about you can put it in an exit bag. But again, go back to the definition of packaging being child-resistant. So that's the outermost packaging, and it's got to have the label, and exit bags don't have labels, so therefore they're not the outermost packaging. And honestly, the definition of packaging excludes exit bags, so go back and watch the other video. All right. Label must contain. I see this screwed up a lot, folks. I see the child, keep it out of reach of children, left off a lot. I see this one screwed up a lot. You must have written on the container or the package, the label. Label must contain, women should not use marijuana or medical marijuana products during pregnancy because of the risk of birth defects or while breastfeeding. Now, let me talk about this or while breastfeeding. First of all, you can clearly tell that they dropped that in as an afterthought because that is not the way in the English language we write a fucking sentence, but that's how they wrote it. They added the modifier or while breastfeeding when they should have said all products during pregnancy or while breastfeeding because of the risk of birth defects. I guess oral or breastfeeding, I guess it's not birth defects, it'd be after birth defects. So I guess, okay, maybe it makes a little more sense now that I'm thinking about it. Anyway, there's two places in the regulations that you need to understand. One place does not have or while breastfeeding in it. Doesn't have that language. Another section of the law says or while breastfeeding. So what I'm going to tell you is put the or while breastfeeding on there so you're in compliance with whichever interpretation they go with. Do you need the or while breastfeeding? Do you not need the or while breastfeeding? Just add the damn thing. It's 4 words. Let's add that. Make sure that's on there. It needs to read it exactly like that. So I'm going to read it to you again. Women should not use marijuana or medical marijuana products during pregnancy because of the risk of birth defects or while breastfeeding. That's what it's supposed to say. And again, I'm going to tell you right now, for some reason, if I mistyped this or something, go check the damn statute, 2612, and go check the regulations and make sure I've got that right, but I'm pretty sure that's exactly right. Somebody would correct me if I said something wrong. All right. Then it also says packaging and labels shall not contain any false or misleading statements. And here's what I'm going to tell you on that. You cannot make any health promises. This cures this. This can be used to treat this. This can solve this problem. Don't make any promises related to the medical benefits of cannabis. We all know that they have them, but you are not allowed to make those kind of statements. It gets into all kinds of issues related to FDA and unsubstantiated claims, and they reference the FDA and a lot of this stuff and adopt CFRs. So just don't put those health-related statements on your packaging, please. You cannot have them. All right, and then it says, no medical marijuana or medical marijuana products shall be intentionally or knowingly packaged or labeled so as to cause a reasonable patient confusion as to whether the medical marijuana or medical marijuana product is a trademarked product. Well, first of all, that makes no damn sense because the company could trademark their product. So it could be a trademark product. It could say TM on it and be a trademark product. I'm going to assume what they mean is you can't make it look like another brand. So in other words, if you're manufacturing a candy bar, you can't make the packaging look like it's a Snickers. I guess that's what they mean by that because otherwise it makes no damn sense whatsoever. So in other words, don't rip off somebody else's packaging and try to market your product as, Snickers THC or something like that. And I don't have permission to use Snickers name, so hopefully they don't sue me. Then next one, no medical marijuana or medical marijuana products shall be packaged or labeled in a manner that violates any federal trademark law or regulation. Well, fucking duh. So don't steal people's trademark. That's an issue. Or regulation, it says. And I guess that means every freaking U.S. code. Broad and ambiguous. One of the reasons why we're going to challenge the law. They do this a lot. They reference other statutes and then they reference federal law and they incorporate it by reference. You can't do that. That's a big problem. It's one of the challenges we're going to put on all these damn laws is because they do that over and over and over again. I don't know if they're just too damn lazy to write it or they just figure, we'll just throw in that and everything else we cannot think about right now, which they do regularly. All right, next one. Packages and labels shall not make any claims or statements that the medical marijuana or medical marijuana products provide health or physical benefits to the patient. I already talked about that in another reference to making false or misleading statements. To me, they kind of go hand in hand. Don't make any of those claims related to health benefits, etc. Okay. keeps going because we're not done yet. That'd be too damn easy. Label requirements, additional label requirements. The label must contain the following at a minimum. 1, the Oklahoma uniform symbol in the manner and form prescribed by the department. Guess what, folks? That is 1/2 inch by 1/2 inch. You have to have the THC red. And by the way, it's got to be in color. They make that very clear somewhere. I don't know if I got my notes. But it's got to be in color. And it's got to be a 1/2 inch by 1/2 inch. I've seen so much packaging where you guys have shrunk it down. You can't do that. 1/2 inch, 1/2 inch. Period. That's what it has to be. If it's not that, and damn it, I believe they're going to take out the damn ruler and measure the damn thing. So make sure it's a 1/2 inch by a 1/2 inch on your packaging. Also, it must have THC potency. So what's the percentage of THC potency in there? It also must have the terpenoid potency. Somebody asked me a question related to this, like, are we supposed to list every terpenoid? No, it says the potency. It doesn't say every terpenoid name and its potency. It just means the terpenoid potency. So get the total terpenoid potency, put that on your label. It's got to be on there. And all packaging and labels must contain this statement, verbatim. This product has been tested for contaminants. Again, this product has been tested for contaminants. So I must say that too. All right. So that's easy, right? That's all we got to have. Oh, wait a minute. No, the hell it's not. We can't be that easy. We're going to be a little more difficult. Okay. The first thing I need to do, we're going to talk about edibles or any food consumptive product that's being sold in a dispensary that contains THC. You need to understand some things about this. This gets complicated, folks, and it's ridiculously written. So let's go through it. There's some definitions I need to give you first as we go through this. Principal display panel. Write that word down if you're following along, taking notes at home. Principal display panel. It says, and I quote, has the same definition as set forth in 21 CFR 101.1 and means, it goes back to that whole thing about they're referencing other things because they were too lazy to write it out. But anyway, set forth in 21 CFR 101.1, go search it on Google and you'll find it too. And quote, means the part of a label that is most likely to be displayed, presented, shown, or examined under customary conditions of display for retail sale. Okay? So in other words, it means in a conspicuous spot where it would be displayed, where how the package would be displayed. Okay? You've got to have your principal display panel. Think about it, this is like your nutrition information stuff. This is the principal. We're going to get into what is on the principal display panel in a minute. But think about this as like the main center part of this information or of your packaging. All right, then, and this is where it gets tricky, and it's where a lot of people are screwing things up, and they're designing these packages, spending a lot of money ordering products without, paying some bucks to me or some other lawyer that's competent to look at your packaging before you go spend all that damn money. This is where people are screwing up. There's also something called an information panel. An information panel, follow along, says it has the same definition as set forth in 21 CFR 101.2 and means, and I'm quoting, that part of the label immediately contiguous and to the right of the principal display panel as observed by an individual facing the principal display panel. You got that? I'm going to read it again. Has the same definition as set forth in 21 CFR 101.2 and means, quote, that part of the label immediately contiguous and to the right of the principal display panel as observed by an individual facing the principal display panel. So we're gonna do a little drawing. Let me see if I can find a blank piece of paper. You would think that a lawyer would have blank paper on his desk, but I don't. So I'll just write on an old note. Forgive my damn handwriting, folks. But look, this is your principal display panel. That's the first thing that somebody sees right there. Immediately contiguous to and to the right of, and from my perspective, it would be to the right of, if I'm looking at the packaging, to the right of, and immediately contiguous to is where you have the information panel. And folks, you're not doing that. You're putting the stuff that's supposed to be on the information panel other places. That's not what the damn law says. It says immediately contiguous to and to the right of the principal display panel. So this is the principal display panel. This is the information panel. That's where it has to be. Contiguous to and to the right of. Can't be to the left. Can't be under it. Can't be above it. To the right of. Or it's weird to do it on the camera when I'm watching it. So it's got to be right here. So, all right, now that we've got that. Now that we understand what the hell a principal display panel are and an information panel, now we have to ask ourselves, well, why the hell do we care what those things are and what they have? So let's talk about that for a second. All right, let's talk about principal display panel. Principal display panel must contain, and if you're following along at home, number 1 through 6. These are 6 things that have to be on there. First, name and address of the business. Second, name of the food. Third, net quantity or weight of contents. 4, ingredient lists. 5, food allergen information. And 6, nutrition labeling if required under 21 CFR 101.9. So you got to go to the federal code and figure out whether you have to have nutrition labeling on there. My guess is you probably do in most cases. So that's the principal display panel has to have those 6 things on it. Okay. Additionally, the principal display panel or information panel. So if you don't put it on your principal display panel, you got to put it on the information panel, immediately contiguous to and to the right of your principal display panel. You got to have these things on there. Number your papers 1 through 7. First thing, list of cannabis ingredients. Next, the batch of marijuana. 3, the strain of marijuana. Optional. So that was optional. 4, THC dosage in milligrams per unit. Number 5, the lot code. Number 6, must contain the statement for accidental ingestion. Call 1-800-222-1222. Again, must contain the statement for accidental ingestion. Call 1-800-222-1222. And then THC sticker, 1/2 inch by 1/2 inch, and clear in plain sight. That's the requirements for what has to be on an edible product. Let's talk about some other things that are in this stuff that we need to look at and pay attention to. First thing, when it comes to label, and it says label means a display of written, printed, or graphic matter upon the immediate container of any article, and a requirement made by or under authority of this article that any word, statement, or other information appearing on the label shall not be considered to be complied with unless such word, statement, or other information also appears on the outside container or wrapper, if there be any, of the retail package of such article, or is easily legible through the outside container or wrapper. Again, that kills the whole freaking exit bag thing that you can do this there. That's can't do it on an exit bag. That's not, you cannot comply with the label requirements on a damn exit bag. So that's another additional requirement on what a label needs to have, what a label is as they define it. And again, just one more time, I've said it enough times, but I'm going to say it one more time. Packaging means that any container or wrapper that a commercial establishment may use for enclosing or containing medical marijuana or medical marijuana products, except that package or packaging shall not include any carry-out bag or other similar container. So in case anybody was confused about any of that stuff I've talked about before, that's what we're talking about. And so let's talk about why is all this important? Why did I spend all this time to go over this crap? And what can you do? Well, as a dispensary, a grower, a processor, you can have check-in sheets for any products that you receive. You need to have a very laid out thing, preferably by an attorney. We're working on developing those here with Viridian Legal Services to get that stuff prepared for our clients so they can check in and check out products. I've already mentioned the company that's talking about doing that, verifying that for everybody. Oh, by the way, I should add this. When you receive an order, you are technically required to verify their OMMA and OBNDD license are still active on every order. So that is a requirement. So be careful there. This company promises that that's part of the services they'll offer as well. Again, I'm going to get with them some more and talk more about that. But if you're a dispensary, you need to have check-in sheets. If you're not a client of mine and you can't afford an attorney for whatever reason, again, I believe in the American dream, but you need to be going through this stuff. I've given it away for free. You need to go through and make a check-in sheet that says, does it have this? Does it have this? Does it have this? Does it have this? And go down it. And you need to have your employees signing off on that stuff, because at the end of the day, if we screw up, if you're an owner of a business and you screw up and don't comply with something, it needs to be because it was an accident or a simple negligence, because gross negligence will get your license revoked. And simple negligence can end up biting you in the rear end with fines and stuff, and they can add up, and that can result in you getting your license revoked. But gross negligence, they can move to get your license revoked immediately. So that's a huge problem, folks. So you need to be aware of these things. And if you're not making these check-in sheets and you're not doing all your stuff related to transport logs now, and making sure that the product coming into you is tested, making sure that it's packaged and labeled correctly, and you're not talking to your purveyors of product about, hey, what are your solutions? You got me out here, flapping in the wind with no ability to fix your product labeling and packaging requirements. And it's not that was their fault. This law came in, and they're scrambling too. But if you're talking to an owner of a company that's not redesigning their packaging to be compliant and trying to figure out your solutions for your products that you have now, then you got problems. If you're a dispensary that's got non-conforming products and you've not written out a policy on how you're going to stop accepting non-conforming products, and this is your plan to get rid of everything that you've got in store, and this is the timeline for getting rid of everything in the store, so you at least have something to fall back on if OMMA shows up and say, hey, look, we're trying to be compliant. We're trying to do it. We've come up with this policy to get rid of this stuff, so we only have conforming stuff. If you're not doing those things to protect yourself, one of two things is occurring. One, you don't have a lawyer, you're not thinking about it. Two, you got an attorney that's not paying attention to what's going on and is not well versed in what's going on. Or three, you're just being grossly negligent, in which case they're going to shut you down if they catch wind to it. So, obviously, I want every business to live or die on the free market, and whether you're better than the next guy. But in this world, to be better than the next guy, you got to be fully compliant, or you're not going to be around to be the better marketer, be the better salesperson, be the better patient advocate, to be the better educator for patients when they come in with your bud tenders. If you're not being compliant fully with regards to all these regulations, then you're probably, it's not going to be a matter of whether you can sell better than anybody else. It's going to be a question of not being around because you get your license revoked for failing to comply with some of these things. And folks, I'll admit to you, it was funny. I had some clients and some new clients. They hired me today, and actually it was like 4 that hired me today. But one of the clients was talking about a lawyer, and you don't know. I've never mentioned this. I'd never heard this lawyer's name before today. But this new lawyer, they were trying to open a small grow operation, and this lawyer that I'd never heard of until today was trying to charge them $2,000 a month and for legal services. And I was like, well, I mean, I could see some businesses needing that much and wanting that much, but he said that was his bottom tiered plan, and it was $2,000 a month, and they're lucky it wasn't higher. And I guess they were lucky that they didn't hire him and came and found me. But anyway, the point is that there is an ongoing need for an attorney to advise you guys as we're going through this process. Obviously, me being hired is how I fund doing this stuff. So I always want to be hired, to represent as many businesses as I can. That's why I'm putting together this team. I've got more attorneys coming in. We're behind on some things. We're keeping up as absolute best we can. We're inundated with a bunch of stuff. We're going to add more lawyers. One of the problems is that I can't raise my prices to where I'm going to drive away people to go hire somebody else, because I just don't believe in doing that. I don't believe in charging, insane amounts of money. You've heard me say before, you can shear a sheep many times, you can skin them only once. And that's the way we work. And so we're putting together a good team. There's some other good lawyers out there. You guys know I think highly of Rachel Bussett. So there's some other good lawyers out there. But the point being, make sure your lawyer's keeping you up to date on what's going on. If you've not heard this from your lawyer, if you've hired a lawyer and you're paying them monthly and you've not heard this information, you're getting it from my Facebook page, ask yourself the question of why you have the lawyer you have. So stay educated out there. Those are the topics of conversation I had for tonight. 59 minutes. I got it done in an hour. I'm impressed. I thought it would take longer. So anyway, I know a lot of you, I can see you guys like posting comments like crazy, asking me all kinds of stuff. Oh, one final thing. If you want to be a client of Durbin Law Firm, as I've explained before, brought in Christina Vaughn. We're going to do an announcement with her tomorrow. Tomorrow's our first official day here. So we'll do an announcement. If she's a little camera shy, I'll see if I can get her on camera or at least get a picture or something. But we'll do that tomorrow. She's interviewing some other lawyers to bring on board. And we've got another new paralegal on board already this week. We've got a lot of great things happening here, putting together a great team that's going to make sure that we carry on what I want. But anyway, if you see something from Viridian Legal Services, that's me too. That's the new, essentially I'm taking all the cannabis stuff and I'm putting it in Viridian so that way I can give my other staff their lives back dealing with the cases that they've been doing for years and they're very, very good at. So we're gonna give them their lives back, and we're building the cannabis dream team, so to speak. But if you've got a question or you need to get an intake from us, you can always email Durbin at durbinlawfirm.net. I'll still always get you the damn thing. You can message me on here. Check out Viridian Legal Services page if you've not checked that out. That's going to be where I'm going to start posting a bunch more stuff as we move forward. But there's just far more reach on this page because it's been built up over the course of a year. You can email for an intake. You can email info@viridianlegal.com. It's in the comments, or it's in the post above. Viridian, VIRIDIAN, or VIRIDIAN, legal.com. So intake at viridianlegal.com. I think it might be info. I think it's intake though. Shit. Excuse me. Sorry. Go with intake. If you get it bounced back, send it to info@viridianlegal. I'll get that cleared up and fixed tomorrow. So I'll have that email address correct, whatever it is. So whatever is up there tomorrow is the right one. And again, you can always just, in the meantime, email Durbin at durbinlawfirm.net. So anyway, going to get to you guys' questions. Hope you guys have a fantastic evening. Stay safe. A lot of other cool and important things coming up. I don't want to spill the beans on just yet. I've made some promises to keep a couple of things under wraps. But I got a lot of cool meetings coming up next week. Not with Adrian Rollins, just so we're clear. I've not got that invite yet. But with some other pretty important people that maybe can help us navigate this issue. And obviously the new director of the Department of Health has not invited me for a meeting either. Anyway, we're going to meet with some other important people and try to get some of these things taken care of and see if we can't get some of these laws fixed as we move forward. So until then, I hope you all have a great night. And like I said, always stay safe.